Welcome back to Beyond Bare Act. Across this playlist, we began with the Information Technology Act's recognition of electronic records and digital signatures. We then followed the law through cyber offences, intermediary responsibility, protected systems, incident response, remedies, and corporate liability. In this final episode, that journey reaches India's transition to the Digital Personal Data Protection Act 2023 and the DPDP Rules 2025. We must ask what is in force on 9th August 2026 and what starts later. Selected structural provisions commenced on 13th November 2025. A narrow consent manager stage is due in November 2026, while the core duties, rights, board powers, penalties, and IT Act transition are scheduled for 13th May 2027. Our fictional composite, Riya, discovers a customer data leak in August 2026. Her organisation cannot simply wait. Current IT Act provisions, contractual and confidentiality duties, sectoral rules, security directions, and incident reporting requirements may matter now. The team should contain the incident, preserve evidence, assess notifications, and communicate accurately while preparing its notices, consent records, rights workflows, retention controls, and breach process for the future regime. This finale separates enacted, commenced, and scheduled law, including the planned omission of IT Act Section 43A. Timing determines which authority has power, which duty is enforceable, and which remedy exists today. The official commencement notification is GSR 843E, dated 13th November 2025. It creates 3 stages. Stage 1 began on publication. It brought into force Section 1, Subsection 2, the definitions in Section 2, Sections 18 to 26 concerning establishment, composition, and administration of the Data Protection Board, Section 35, Sections 38 to 43, and subsections 1 and 3 of Section 44. The government separately established the Data Protection Board of India through GSR 844E, with its head office in the National Capital Region, and notified a 4-member composition through the accompanying notification. Do not infer that every substantive board power was therefore live. Section 27's principal powers and functions were not in the immediate group. Stage 2 begins 1 year from publication on November 13th, 2026. It brings into force Section 6, Subsection 9 and Section 27, Subsection 1, Clause D, the provisions tied to accountability and registration of consent managers. On our update date, that stage is still in the future. Stage 3 begins 18 months from publication, on 13th May 2027. It brings into force Sections 3 to 5, most of Section 6, Sections 7 to 17, the rest of Section 27, Sections 28 to 34, Sections 36 and 37, and Subsection 2 of Section 44. That group contains the core application, processing grounds, notices, consent, data fiduciary obligations, data principal rights and duties, board enforcement procedure, appeals, alternate dispute resolution, penalties, and the IT Act Section 43A transition. When writing a legal update, give the notification number and date, then state the precise stage. Avoid phrases such as DPDP became fully effective in November 2025. Rules were notified and implementation began, but the core statutory obligations were deliberately scheduled later. The calendar is part of the law. As of 9th August 2026, the Data Protection Board is established in law, and the Act's structural provisions in Sections 18 to 26 are in force. Those provisions cover establishment, composition and qualifications, terms, disqualification, resignation, proceedings, officers, public servant status, and powers of the chairperson. Section 2's definitions are also in force, along with selected miscellaneous provisions such as good faith protection, consistency, bar of jurisdiction, rule-making and related machinery. but the principal powers and functions in Section 27, the procedure in Section 28, appeal in Section 29, execution, alternate dispute resolution, voluntary undertaking and penalties in Sections 30 to 34 are in the 18-month group except for the narrow consent manager registration function scheduled at 12 months. This matters for public guidance. A person affected by a leak in August 2026 should not be told, without verification, that a fully operational DPDP complaint and penalty route is presently available under provisions that have not commenced. Current remedies may arise elsewhere, and the organisation should still respond responsibly. It also matters for the board itself. Establishment is not the same as possession of every future substantive power. The notification staged the institution before the full enforcement workload. Riya's company receives a customer email demanding action under a future DPDP right to erasure. The company may honour a reasonable deletion request under its contract, privacy notice or current policy, subject to retention duties. It should not falsely state that Section 12 is already enforceable. Section 12 is scheduled for May 2027. An accurate reply can explain the present basis for action and the organisation's readiness process. This is not a loophole strategy, a company that delays security or rights engineering until the night before commencement is likely to fail. The correct position combines present law accuracy with future law preparation. Do not invent an enforceable duty, and do not ignore the coming one. When the core provisions commence, Section 3 applies the Act to processing of digital personal data in India, where the data is collected digitally or collected non-digitally and later digitised. It also creates extraterritorial reach for processing outside India connected with offering goods or services to data principals within India. The section excludes processing by an individual for a personal or domestic purpose, and personal data made publicly available by the data principal or by another person under a legal obligation, according to the statutory wording. Because Section 3 is not yet in force on our update date, describe this as the scheduled scope, not a present universal rule. Section 4 then permits processing for a lawful purpose with the data principal's consent, or for certain legitimate uses specified by Section 7. Data fiduciary means the person who alone or with others determines the purpose and means of processing. A data processor processes on behalf of a data fiduciary. The labels carry accountability. Outsourcing the database does not outsource the data fiduciary's statutory responsibility once the obligations commence. Consent is not the only future ground, and certain legitimate uses are not a general convenience exception. Each processing activity should be mapped to the actual ground and purpose. Riya's company stores customer purchase history, support recordings, employee access logs, and fraud indicators. One privacy notice cannot explain all four through a vague phrase such as service improvement. Build a processing inventory with data category, purpose, data principal group, collection point, ground, processor, sharing, retention, security control, and deletion trigger. Mark where law or contract requires retention. Identify data collected only because it was easy. This work supports current security and future compliance. It also prevents a common misconception. The DPDP Act is not a database registration law that blesses processing once a form is filed. The future regime asks whether a specific lawful purpose and statutory ground support each processing relationship, with continuing duties around accuracy, security, erasure, and response. The scheduled notice and consent provisions are designed to make processing understandable at the point of decision. Section 5 requires notice describing the personal data and purpose, the manner of exercising rights, and the route to complain to the board subject to the Act and rules. Section 6 defines consent as free, specific, informed, unconditional, and unambiguous, signified through clear affirmative action and limited to personal data necessary for the specified purpose. Consent can be withdrawn, and the ease of withdrawal should be comparable to the ease of giving it. The 2025 rules add operational detail about clear presentation, itemised information, and access to the required routes when the relevant provisions commence. Consent records must therefore answer more than yes or no. What notice version did the person see? In which language? For which purpose and data? What action expressed consent? When was it withdrawn? Which processes and systems received the change? Riya's platform bundles delivery updates, personalised advertising and sale of contact data into one mandatory switch. Under the future framework, those distinct purposes require careful separation and necessity analysis. Refusing optional advertising consent should not be designed to block a service that does not need advertising data to operate. Current contract and consumer rules may already constrain dark patterns, even before the DPDP provisions commence. A readiness program should redesign the interface, but it should also redesign the back-end. If withdrawal change is only a front-end flag while marketing exports continue, the experience is misleading. Build a consent ledger connected to processing systems, version notices, test accessibility, and create escalation for conflicts with legal retention. Do not delete evidence or statutory records simply because consent was withdrawn, where another lawful basis or legal duty controls. Document the decision. Consent is a legal relationship carried by systems over time. A compliance screen without an executable downstream instruction is merely theatre. Section 8 contains the future general obligations of a data fiduciary. The data fiduciary remains responsible for processing done on its behalf, irrespective of an agreement to the contrary, and may engage a processor only under a valid contract. Where personal data is likely to be used to make a decision affecting a data principal or disclosed to another data fiduciary, completeness, accuracy, and consistency matter. The organisation must implement appropriate technical and organisational measures and reasonable security safeguards to prevent personal data breaches. When a breach occurs, it must notify the board and each affected data principal in the prescribed form and manner. It must erase personal data when consent is withdrawn or the purpose is no longer served, unless retention is necessary for compliance with law, and cause its processor to erase too. It must publish a contact point and establish grievance handling, subject to the section and rules. These obligations are scheduled for May 13th, 2027, but they describe systems that take time to build. Riya's company uses a cloud processor and 3 sub-processors. The contract says only that the vendor uses industry standard security. That phrase does not allocate incident timelines, evidence access, deletion, sub-processor controls, audit, assistance, or return of data. Readiness means amending the contract and the technical integration. The company should know where customer data is stored, who can access it, how encryption keys are controlled, which logs exist, how quickly the processor reports a breach, and how a deletion instruction propagates. Retention must be purpose-based and law-aware. Keeping everything forever increases breach impact. Deleting everything immediately can violate legal duties and destroy evidence. The future obligation is not to pick one extreme. It is to define, implement, and document the life cycle. The 2025 rules add detail on safeguards, breach intimation, and retention for specified classes when those rules commence. Organisations should test the process now with tabletop exercises, because a breach deadline cannot be met by discovering the processor chain after the incident. The future DPDP framework gives data principals rights to information about personal data processing, correction and erasure, grievance redressal, and nomination. The access right is structured by Section 11 rather than being an unlimited demand for every internal document. Correction and erasure operate subject to the processing purpose and legal retention. Grievance redressal should ordinarily be used before approaching the board once the enforcement route commences. Nomination allows another individual to exercise rights in the event of death or incapacity according to the Act and rules. Section 15 also gives the data principal duties: comply with applicable law, avoid impersonation when providing personal data, avoid suppressing material information in specified contexts, furnish authentic information when exercising correction or erasure, and avoid false or frivolous grievances or complaints. These duties do not let an organisation obstruct a genuine request by calling it inconvenient. A rights process should authenticate proportionately, search relevant systems, explain decisions, and track deadlines without collecting excessive new data. Riya's platform receives a correction request for an address. The customer can authenticate through the existing account, so demanding a notarized identity bundle would be disproportionate. A deletion request is more complex because tax and fraud records have legal retention. The response can erase marketing and dormant profile data, restrict retained records to the legal purpose, explain what remains, and record the retention trigger. Build a system inventory that can answer rights requests across processors, backups, and derived datasets. Decide how deletion reaches models, analytics tables, and exports. Maintain an exception register with legal basis and review date. Train support staff not to promise instant deletion of every copy or to deny the whole request because one category must be retained. On August 9, 2026, these statutory rights are scheduled, not fully commenced. A company may nevertheless offer similar contractual rights today. If it does, the promise should be accurate and executable. Rights build trust only when the organisation's data map is real enough to find and act on the data. The scheduled framework adds targeted duties where risk is higher. Section 9 addresses processing of children's personal data. It requires verifiable consent of a parent or lawful guardian before processing, subject to the Act and rules, and restricts processing likely to cause detrimental effect, tracking or behavioural monitoring and targeted advertising directed at children, with notified exemptions for specified classes or purposes. The rules provide operational detail and exceptions that must be read carefully. Age assurance should not become uncontrolled collection of more identity data than necessary. Section 10 allows the central government to notify a data fiduciary or class as a significant data fiduciary based on factors such as volume and sensitivity of data, risk to data principles, sovereignty, integrity, electoral democracy, state security, and public order. A significant data fiduciary must appoint a data protection officer based in India, engage an independent data auditor, undertake impact assessments and periodic audits, and comply with additional prescribed measures. Section 16 permits the central government to restrict transfers of personal data outside India to notified countries or territories, while Section 38 preserves stricter protection under other laws. It is therefore inaccurate to summarise the future Act as unrestricted global transfer or universal localisation. The DPDP rule, notified restrictions and sectoral laws must be read together. Riya's platform serves families and cannot reliably tell whether an account belongs to a child. Readiness begins with product design. Who is the audience, which features profile behaviour, what age or parental process is proportionate, and can the service function with less data? For significant fiduciary readiness, governance should not wait for notification to create basic accountability. Assign an owner, perform a data risk assessment, and plan independent review. Cross-border mapping should identify actual storage, remote support, and backup locations, not merely the vendor's registered office. The legal categories commence in May 2027, but architecture decisions made today may determine whether compliance is practical then. The Digital Personal Data Protection Rules 2025 were notified with a corrigendum and their own staggered commencement in Rule 1. In broad structure, board administration and digital office machinery begin first. The consent manager framework follows the 1-year stage, and the rules supporting the main notices, consent, security, breach, rights, retention, and other substantive obligations follow the 18-month stage. Always read the exact Rule 1 clauses in the official corrected text before assigning a present duty. A rule may exist in the Gazette while its operative date is future, just as an Act section may be enacted but not commenced. The rules translate statutory phrases into operational detail. They address what a notice should contain, how consent managers are registered and governed, reasonable security safeguards, breach intimation, retention for specified data fiduciary classes, verifiable parental consent, exemptions, significant data, fiduciary measures, rights and grievance routes, processing outside India, research exemptions, and board procedure. The Act supplies the power and duty. The rules often supply the form, manner, time, or detailed control. A compliance matrix should therefore have paired columns: Act provision, rule, commencement date, business owner, system implementation, evidence, and test result. Riya's company has a breach playbook written from the draft rules. The final 2025 rules and corrigendum must replace the draft. The team compares notification recipients, content, timelines, and system dependencies against the official final text. It tests whether the processor can provide facts quickly enough and whether customer communications can be issued in clear language. It also marks the playbook as future DPDP readiness while preserving current cert-in, sectoral and contractual reporting routes. This prevents two opposite mistakes: delaying all work because the core stage is future, and misrepresenting a future DPDP deadline as today's binding deadline. A mature legal update carries status beside every control. The word notified is not the same as the word commenced, and neither word guarantees that an organisation has actually implemented the requirement. DPDP Act Section 44. Subsection 2 amends the Information Technology Act by omitting Section 43A, adding a DPDP reference to Section 81's proviso, and omitting Section 87 subsection 2, Clause OB, the rulemaking hook for reasonable security practices and sensitive personal data. But GSR 843E places subsection 44.2 in the 18-month group. On 9th August 2026, Section 43A therefore remains in the IT Act. It still provides compensation where a body corporate possessing, dealing with, or handling sensitive personal data or information in a computer resource is negligent in implementing and maintaining reasonable security practices and procedures, and thereby causes wrongful loss or wrongful gain according to its current text. The 2011 SPDI rules and case-specific law may remain relevant to the present route. Do not write Section 43A has been repealed today merely because the future amendment is enacted and scheduled. On May 13th, 2027, absent a further legal change, the omission and the core. DPDP obligations commence together. The architecture shifts from the narrower Section 43A compensation model for sensitive personal data handled by a body corporate toward the broader DPDP framework for digital personal data, data fiduciary obligations, board process, and scheduled penalties. That transition does not erase every IT Act privacy or security provision. Sections 72 and 72A have different actors and elements. Cyber offences, confidentiality, contracts, sectoral rules, and other laws continue according to their own terms. Riya's August 2026 leak analysis can therefore consider current Section 43A, present contractual and incident obligations, and future DPDP readiness. If a proceeding begins before the transition or concerns earlier conduct, savings, accrued rights, and procedural questions may require specialist advice. This episode does not resolve them. The SAFE educational statement is date-specific. Section 43A is still present on August 9th, 2026. Its omission is scheduled for May 13th, 2027 under DPDP Section 44.2. Bring the last 6 episodes together. Riya's company supports a hospital platform. An unfamiliar contractor account attempts remote access. A digitally signed change request appears to authorise maintenance, the approval control is disabled, and customer data is exported. First, Episode 8 asks whether the evidence is preserved, lawfully collected, imaged, hashed, certified, and attributed. A screenshot of the alert is a lead, not the whole proof. Section 75 and cross-border evidence rules may matter if the cloud logs sit abroad, while Section 78 identifies the investigation rank. Second, Episode 9 asks whether the target is within a protected system notification, who had written access authority, and whether NCI IPC, cert-in, or sectoral routes apply. Operational importance does not substitute for the Gazette. Third, Episode 10 verifies the signed change request. The certificate chain and signature validate, but the subscriber lacked authority and key control evidence suggests compromise. Cryptographic validity does not legalise the change. Fourth, Episode 11 separates compensation, penalty, and offence routes, values the claim, identifies the adjudicating officer or competent court, and preserves appeal deadlines. Fifth, Episode 12 maps the engineer, manager, contractor, and company to abetment, attempt, Section 85 and due diligence without naming uninvolved directors. Sixth, Episode 13 states privacy law by date. In August 2026, current IT Act Section 43A and other present duties may apply. The main DPDP obligations and penalties are scheduled for May 2027. The organisation still uses the future framework to improve notices, processor contracts, security, breach response and retention. Every layer shares evidence but asks a different question. The right workflow is preserve, protect service, identify the resource, verify authority, classify current law, attribute cautiously, notify through verified routes, choose the correct remedy and update the conclusion as evidence changes. Riya is fictional. The facts accuse no real person or organisation. The case is a method for avoiding both panic and false certainty. With that, our journey through the Information Technology Act reaches its conclusion. We began with electronic records and digital signatures, then followed the Act through cyber offences, intermediary duties, protected infrastructure, incident response, remedies and corporate responsibility. We end at the DPDP transition. The larger lesson is not to memorise isolated sections. Read the current primary text, record its date, identify the actor and legal trigger, preserve the evidence, choose the correct process and state the conclusion with its limits. Distinguish an account, device, certificate, organisation and human identity. Verify legal authority separately from technical capability. And where privacy is involved, always state the law by date. On 9th August 2026, the DPDP board structure exists, the consent manager stage is approaching in November 2026, and the core regime, including the scheduled omission of IT Act Section 43A, is due on 13th May 2027. Communicate carefully. Confirmed, supported, inferred, disputed or unknown. Protect people without inventing an attacker and remediate the system without overwriting evidence. This is what Beyond Bare Act means by going beyond the bare provision, connecting legal words with institutions, technology, proof and responsible decisions. This programme is educational content, not legal advice. Laws can change, and a real matter requires current professional advice. Riya is a fictional composite, not a real allegation. If this series helped you understand the Information Technology Act beyond isolated provisions, share it with someone who may find it useful, and subscribe for more clear, source-based legal explainers. Tell us in the comments which law you would like us to examine next. This is Beyond Bare Act, what the law says, what it does,